Hello, and welcome back to Multimedia Law. This week we're going to be talking about Chapter 5 of Digital Media Law by Ashley Packard, Conflict of Laws. So let's say that I'd published something and it injured your reputation. You decide that you want to sue me, but I'm located in Alabama and you're in Malaysia. That creates a situation called conflict of laws. The first question you have to deal with is which court has jurisdiction? Is it Malaysia or is it Alabama? Which laws apply when you get into that court? Malaysian laws or Alabama laws? Those are the questions we are talking about today when we discuss the issues of conflict of laws. The internet is everywhere, but the world is made up of solid territories, states and nations that do not always agree about the suitability of content that crosses their borders. This is true between countries, but also within countries. In a place like the United States, we have 50 states plus some more jurisdictions, so you have conflict of laws between those states as well as between the United States and other countries. A lot of countries, they like the benefits of the internet. Digital media's power to extend science, art, and commerce is amazing. On the other hand, they worry about defamation, obscenity, hate speech, and fraud, and perhaps about political speech that doesn't serve the interest of the government. So they sometimes try to fight the content that they don't like. States will prosecute publishers in other countries who disseminate content they consider illegal. For example, they will allow their citizens to sue content producers in other countries for material that was believed to have caused harm. In some cases, they will even allow non-residents to sue other non-residents in their courts for online content that was seen or received within their borders, even though those people weren't present in those countries. Here are just a few examples of this happening. Dow Jones, that's a company in the United States, was sued in Australia and the United Kingdom for material that was accessible through its Barron's Magazine and Wall Street Journal websites. I'm going to talk a little bit more about that one in a few minutes. The Washington Post newspaper in Washington, D.C., was sued in Canada for a story about an African United Nations worker. 2 Russian citizens sued Forbes in the United Kingdom about an article it published. A French court found Yahoo, the internet search engine, guilty of listing Nazi paraphernalia on its website. That was illegal in France. And Germany tried and convicted an Australian for operating an English language Holocaust denial website. Conflict of laws is an area of procedural law that addresses how to treat conflicts between people who are litigating each other from different places, and it addresses the question of which nation or state laws will apply. In the United States, the area of conflict law has 3 distinct branches, and similar rules apply internationally. The first of these branches I mentioned is jurisdiction. The question of which court will be the forum court, meaning the court that has the right to hear and decide the case. If you live or do business within a court's geographical area, for example, you may be subject to its jurisdiction. The second is choice of law, meaning which country or state's law will apply in a particular case. And the third is enforcement of judgment. Once you get a judgment against me, let's say you sue me in a Malaysian court and you get a judgment against me, the question becomes, will Alabama help you collect the money that I owe you? A plaintiff who wins a judgment against a defendant who lives in another state or nation must petition a court within the defendant's jurisdiction to enforce the foreign judgment. In the United States, it's important to the courts to achieve due process, the fair application of legal procedures. Due process is guaranteed in the U.S. Constitution. It states that no person may be deprived of life, liberty, or property without due process of law. So a court, in considering these three issues, jurisdiction, choice of law, and enforcement of judgments, may take those things into consideration. For example, if a court decides that a foreign judgment was not achieved through due process of law, it may choose not to require that judgment be paid. There's a case known as Zippo from 1997, in which a federal court concluded that a website operator's contacts with the forum should be assessed on sliding scale based on the website's level of commercial activity and interactive ability. This case is not recognized in all jurisdictions, but it's provided some guidance to the courts. This diagram is from our textbook. On the left side, you see that if a website's relation to a particular location is non-commercial and passive, jurisdiction may not be appropriate for courts in that location. Non-commercial means not engaging in business activity in that area. Passive means that the site does not require or expect much interaction with readers. Readers simply read what's on the website. Jurisdiction, on the other hand, may be appropriate if commercial transactions are conducted with customers in the area in question and if there is interaction, such as an exchange of files and contracts, and so forth. The things we're talking about here generally fall under the umbrella of private international law. What this means is disputes between private individuals, corporations, or organizations that are located in different countries. I'm going to give you some examples of how these questions played out, but I'm not going to pretend to give you a comprehensive notion of how these questions are resolved because it is quite complicated. Libel means defamation. It means harming somebody's reputation, and often media law involves a question of libel. So there was a libel suit that I mentioned earlier that I want to give you a little bit more information about. It involved internet publishing, and the case was Dow Jones versus Gutnick. Dow Jones is the publishing company that publishes the Wall Street Journal, Parents Magazine, and a number of other publications. The plaintiff, Mr. Gutnick, was a businessman in Australia, and he sued Dow Jones. The suit involved an article implying that Mr. Gutnick was involved in money laundering, which can be an illegal activity. Money laundering is where you hide the source of money. I pay you so that you can pay someone else, so that the other person doesn't know the money came from me. The article in question was published in the United States, but could be seen in Australia if you had an online subscription to Barron's magazine. Dow Jones argued that Australia was an inconvenient forum or location for the suit because its editorial offices and servers, so internet servers, were in the United States, along with about 95% of its subscribers. But Dow Jones had 1,700 subscribers in Australia, including several hundred in Mr. Gutnick's home city of Victoria. The trial court decided that Victoria was the more appropriate forum for the suit because any harm to the plaintiff's reputation was likely to have occurred there. In the appeal, the High Court of Australia agreed with the trial court and decided that publication actually took place where the material was downloaded. Here is the quote. Those who post information on the World Wide Web do so knowing that the information they make available is available to all and sundry without any geographic restrictions. That's what the court said. Now, when cases like this happen, it invites people to engage in what's sometimes called libel tourism. This means filing suits in countries that are especially plaintiff friendly. The United Kingdom, for example, is seen as more plaintiff friendly than the United States. The United Kingdom Supreme Court of Judicature cited Gutnick when it upheld a lower court's assertion of jurisdiction over an internet libel case in which both the plaintiff and defendants were U.S. residents and the website carrying the disputed material was based in the United States. The plaintiff in this case was boxing promoter named Don Johnson in the United States. The case seemed to have no connection to the United Kingdom other than the websites can be accessed there. The UK court that claimed jurisdiction pointed out that King was well known in the United Kingdom, so he had a reputation there to protect. Don King produced evidence that UK boxing fans had read the website and knew about the accusations made against him. So I guess the bottom line is it's complicated. Drawing on the boxing connection of the case I just described, here is another illustration that is in your textbook. It's the battle royale for legal supremacy, your laws versus their laws. The venue to be decided on a case-by-case basis. In other words, you never really know for sure how it's going to turn out until you take a particular case to court. You get free admission to this battle if you happen to violate another country's laws, and then somebody drags you into court in their country. It's not a battle you generally want to be involved in if you are a defendant. Let's talk about the idea of comity, which means reasonableness. A nation or state applying its law to particular individuals and circumstances is obligated to consider the interest of other states that might have a connection to the controversy. This doctrine of comity says the courts of each country should consider the aims and interests of other states in order to further cooperation, reciprocity, and international courtesy. The comity doctrine suggests unless there's an overwhelming reason not to honor the judgment of a foreign court, a court should honor it. But the court may decide not to honor the judgment if it considers the judgments to have been rendered by an unfair court, or one that did not have jurisdiction, or maybe the judgment was obtained by fraud, or maybe it was contradicted by a valid earlier judgment. Those are reasons that a court may decide not to honor the judgment of a foreign court. We mentioned earlier the question of free expression and the First Amendment of the United States. The judgment was against the First Amendment. That might be a consideration here, if that were the case. American courts have used a public policy exception to reject judgments that would undermine First Amendment protections. That's what we are talking about here when we say the First Amendment might apply. In 2010, Congress passed an act that is called the Securing the Protection of Our Enduring and Established Constitutional Heritage Act. That may seem to be a convoluted title for a law, and it is, but it was written that way so we would have a nice acronym, and that acronym is SPEECH. SPEECH. This law is intended to uphold U.S. policies extending greater leeway for speech and defamation cases. This law was meant to discourage libel tourism, the practice of shopping from the friendliest forum in which to file a libel suit. I'm going to say the name of this again because I think I might have mispronounced one of the words. Securing the Protection of Our Enduring and Established Constitutional Heritage Act. It was enduring that I mispronounced the first time. Several states in the United States now require their courts to refuse to enforce libel judgments against their residents if the judgments were rendered by foreign courts that lack the same speech protections guaranteed by the U.S. Constitution and their state constitutions. However, these laws may not apply to matters other than libel, and the Speech Act does not override criminal convictions in other countries. It is not going to help you if you're convicted of committing a crime in another country. I'm sure you have all seen terms of use on many websites and with software you may have purchased. It's a bunch of fine print, and I'm guessing that you don't read all the way through it before you click OK. I'll confess that that's the way I treat it. I barely even glance at what it says. I just click OK. It's common for companies to put clauses in those terms of use and other contracts to specify the jurisdiction and the law that would apply if a legal dispute should occur. So you might find that when you click on OK or I accept on terms of use, that you are agreeing where any disputes will be settled, and it's usually in the place that's most advantageous to the company that's publishing the website. Here you can see an example of eBay's terms of service from a few years ago, and I expect they're still very similar today. It says, "This agreement shall be governed in all respects by the laws of the state of California without regard to conflict of law provisions." You agree to submit to the personal jurisdictions of the courts located within the county in California where eBay must be located for the purpose of litigating all such claims or disputes. Nations are trying to resolve issues of conflicts of laws by negotiating treaties. Those, of course, are agreements between countries, sort of a contract between countries, outlining how they're going to treat patterns of international law that come between them. These have not always been very successful, these efforts to negotiate treaties. Other approaches that go around the courts, I guess you would say, include arbitration, which is a dispute resolution process where you have a legally trained, neutral third person or panel of experts to hear disputes and render verdicts. They take the place of the judge and the jury. You also may decide to engage in mediation, which is where the disputing parties work together with a neutral mediator to agree on a solution. In other words, it's a negotiation and the guidance of this neutral party. The attraction of mediation and arbitration is that they're faster and often less expensive than going to court. Here's a good quote from the European Union Vice President of Parliament that explains why nations can't always readily agree on how to handle conflicts of law. The problem is clear, the person said. They don't want to be subject to each other's laws. The UK media will tell you that they don't want to be subject to French privacy laws. Look at it from the French side. They are scared silly about damage awards to the UK. Now, if you want to stay out of trouble in foreign jurisdictions, you might be able to find a technological solution. Not everything that you put on your website is necessarily available to be seen in every country. Publishers are not always sure where they may be liable for the content they publish, so some of them are experimenting with what's called geolocation software that restricts access to regions from particular countries. An example is a story that ran in the New York Times about a terrorism case in Britain. It described what police had found and what the Times, I guess, had found about a case in which London police arrested more than 20 people for plotting to set off explosives on transatlantic flights. The concern was, from the perspective of the Times editors, that although the story was fine under US law, they might get in trouble in the United Kingdom because of a law that forbids publishing anything about an arrested person that might bias the jury. Editors at the Times actually could have gotten thrown in jail for publishing that story, possibly in the United Kingdom. So, being cautious, they chose to prevent British readers from accessing that article, and they used the same software that they currently used routinely to direct advertisements to readers in particular geographic locations. Now, something that may be more relatable to you is something like Netflix. Netflix and many other streaming services use geolocation filters. Netflix engages in geolocation filtering or something similar to make shows available in certain countries but not in others. One of my friends who lives in Spain is unable sometimes to get content that I'm watching in the United States because it hasn't become available to Netflix in Spain yet, and they use geofiltering to prevent her from accessing it. It is always very disappointing because then we can't talk about the show. Well, we're getting towards the end here, so I'm just going to throw out some questions for you to discuss as usual. The first one is, if you publish something on the internet that harms someone in another country, where do you think that person should be able to sue for damages? In his country or in your country? Why or why not? The second question is to go back to the first question and put yourself in the other person's shoes. Would you still feel the same way? I look at it from his point of view, and then why or why not. Number 3, due process is the idea that no person can be deprived of life, liberty, and property without due process of law. If a nation values due process, why might that lead it not to honor a court judgment rendered in another country? Number 4, do you actually read the terms of service before you click OK on a website? Why or why not? If you don't read those terms of service, how can you be sure that you're not giving away important rights? Does this worry you? Why or why not? Thank you for your attention. I hope you're having a great week, and please make sure that before the end of the week, that you submit your discussion responses. I look forward to reading them.